CPC. You're not talking about the CPC.
Is that
Criminal procedure, that's what he's talking about.
No. I'm talking about, we have agreed that CPC, this criminal procedure and the international crime, shifted.
Yeah.
This is the one that we were supposed to handle.
added in that list.
Okay.
So what did Mr. Mani say? Mani. Because Mani was there and he was very meticulous. He taking all the details, yes. He's not Mani.
The editor at the
one we went.
Okay, Lamin Mani.
Yes.
Yeah. In fact,
So he was the key person taking all the details in his computer. And they actually printed it. I could remember even editing the printed version and giving that to them. So I don't know. He did not say anything, you could not see it.
yeah, so that's the difficulty we are. Get the corrupt version. So at one point we are seeing also a report that is talking about the 2019 version, which we are very sure that the 2019 version was withdrawn.
It was.
And now we are living with this. Yeah. So we are definitely in a confusion state, and we do not want to put this. This is a very critical thing. You must be aware. And then, based on those reasons, so we do not want to put the committee in that state of environment. So our best advice as officers is to this committee go to. Yeah, I mean, yes, at the committee level, I mean.
suspend.
From the schedule, yeah.
Do, Chair, do we suspend, adjust time for us?
Let's get what he wants to say here.
As I'm saying, we seek permission from the plenary to give us more time on the two bills, both the criminal offenses and the CPC.
Yeah.
Because my problem is, in fact, whether we should deal with the criminal offenses separately, introduce that, pass that without this other one, because they go together. They have a lot of link. I thought when we are doing them, we should do them together, so that we will not miss anything that we do here that we have not done. So I think if we can do that.
Yeah.
And when that goes into the new parliament, well, that it goes into the new parliament without us saying, let's suspend it or we withdraw it. But the parliament has already passed through that. That's what I'm
It's
thinking.
just that, like what we've been doing before.
Exactly.
We'll go back to plenary to ask for an extension.
Exactly.
To next session.
That's what I mean.
Because I think there's a 13-week period.
Yeah.
Am I right?
Yeah.
Yeah.
16, sorry.
16, 16 weeks now. But we know that the bills that were referred to the committees were so many, and this is not a clean bill.
Yeah.
Honorable Njai.
Yeah, I think he just mentioned what I was about to say, just to postpone it and ask him, because we cannot pass anything to them.
No, we just ask for
Extensions, yeah.
Now, just to, a matter of fact, that criminal law and criminal procedures are very technical, not only interrelated, but very, very technical. And you need experts, and not only academic experts. You need people who are highly experienced in criminal procedural matters at the advocacy level, that is at the courts, to come and guide the committee, give their experiences, the challenges that they face with the present law, to justify the need for the new proposal. So it's something that it is not to be rushed. In as much as we want to do it, Parliament, I mean, it's our advice that when you bring in resource persons, bring in lawyers who are active criminal lawyers. They practice criminal law. We may have practicing lawyers, but they may be constitutional lawyers or civil case lawyers, not necessarily criminal lawyers, and equally so from the criminal division of the Ministry of Justice to bring them on board. So I would agree that we allow or we request from the plenary to have an extension to the next session, and whenever it's there, it can be worked on. So if that is agreeable to honorable members, take that decision. And then, please, Honorable Clark and Mr. Senior Legal Officer, take note now.
Thank
We
you.
have the Solicitor General
Huh?
outside.
Yeah, that's again.
So we're going to the next item.
You come back.
The next item will be the final consultation with the removal of the prevention and prohibition of torture bill. You will recall that what we did was that clarification that I raised. And I think this SG, the Honorable SG is around, the representative from the Ministry of Justice. We can invite him to
Can I
come.
ask
He
a
has,
question? Can I ask?
Mr. Diva has circulated a document.
Yeah, can I-
Yes, you
I've
should.
just seen it myself.
Can I ask a question?
Yeah, you should.
Yeah, and
Huh?
we are going to ask for extension on that.
No, I think that one
No,
was.
that one is gone.
I don't know whether it was present, but that one was almost completed. All we
But you
wanted.
said we have to put them all together.
No, that's a criminal and
Criminal
criminal
offenses.
procedure.
This is prohibition of torture and prevention of torture.
Convention.
This is the prohibition of torture.
I think he's making a reference. He printed a Uganda passport. Yes.
Please indicate that. No wonder I'm asking.
There is there. Uganda passport. His name was
We don't
there.
recognize torture.
Where? Okay. I was wondering. Because I'm
It's just an example.
Yes, thank you.
The
Right.
difference is almost
Yes, you can. Why don't you? Okay. Mr. Diba, Mr. Thomas is out.
Madam Speaker, the whole of this assembly, there is no, the whole of this assembly, there's no trash bin. So you have to carry your trash.
None of this assembly.
The whole of this assembly, there's no trash bin. There is, where?
Everywhere.
Huh?
Dustbin.
Here, outside.
Even inside.
Yes. Outside,
It's
inside,
there,
inside.
at the corner.
Team, you're welcome to the National Assembly, and this is the Committee on Human Rights and Constitutional Matters of the National Assembly. Some time back, I think it was in 2020, the minister tabled the Prevention and Prohibition of Torture Bill 2020. And after the second reading, it was referred, committed to the committee for scrutiny and consideration for the committee to prepare a report and submit it to the plenary of the Assembly. Now, we had series of consultations and I think workshops. Honorable Chair, I did not attend the workshops, but the Vice Chair attended and almost all members were there. And we made quite a lot of progress. But one issue that came up during the course of discussions and we could not agree on was the definition of torture. Now, under the this is it? This is it. So can I have the bill itself, please, if you have it? What are those three? So, Mr. SD, you have your bill.
I do, Honorable Speaker. Thank you.
Thank you. Now, specifically on the part 2, prohibition and criminalization of torture. 3 definition of torture. In this act, torture means any act or omission by which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person by or at the instigation of, or with the consent or acquiescence of any person, whether acting in an official or private capacity for such purposes as it details in ABC. Now, during the course of our consultation, I stand to be corrected, honorable members were satisfied with this definition generally, but an expert from the UNDP office was invited during the course of the consultation, and he said the Parent Act, this is a domestication of the Parent Act. Now, private capacity is not included in the international treaty. So that became an issue. And I said, okay, well, the movers of the bill, maybe they be able to explain why they think that it should be here. Because if it is, no, let me not, but that if it is not included, you take it there, people will, why? Why not in their private capacity? So we want to hear from you, what's the rationale? Are you satisfied with the inclusion of private capacity to exclude the expert advice of whoever? I was not there, but what I will do is I will allow the honorable members who were at that consultative workshop, the person of Honorable Toure is the vice chair of the committee, and any other honorable member who wishes to make a statement seeking for clarification on this matter. So that is the essence. I think, is that right?
Yes.
That is the main reason why we have called you. Otherwise, we could have finalized it. Because I think everything was okay with us as far as our scrutiny was concerned. So, Honorable Vice Chair,
Yes, thank you.
you can take us.
As we have said on the UNDP, she advised that under international law, torture is only capable of being committed by persons acting in an official capacity, not by private people. That when torture is committed by private individuals, it falls under the ruling of other criminal offenses, such as assault causing actual bodily harm, etc. So what she's saying, there are many laws that take care of all those criminal activities. But when it comes to specifically torture, it can only be committed by somebody acting under the authority of the state. That is the argument that she's made there. And we were generally convinced, like she said, but still, since the ministry has put it there, private person, we still want to ask why or whether you will be satisfied with this focal person's observation.
Any observations, statements on that?
Essentially, that's that.
Essentially.
I've always had that also be at a private capacity, because somebody can have more influence over a person. For example, somebody who is richer and can have more advantage can also torture. We have seen it happen. You can live in the streets with somebody, meanwhile you're torturing them mentally, psychologically. That is not in an official.
I think we are on the same
official
level with the ministry.
No. What I'm saying is that I'm disagreeing with what that focal person said. That is at an international level, but at a domestic level, it can be from a private person. That's what I'm saying.
That is why.
I think for now, let's reserve our opinion.
Yes.
And then hear from their side, and after we can value the
You
truth.
may convince us and then we just limit
Yeah.
into.
We balance the two.
So,
Honorable members of the Human Rights and Constitutional Affairs Committee
Is it on?
is on. Honorable Speaker, I am very privileged to be here this afternoon. I am humbled at the invitation, and I am here with Senior State Counsel Mrs. Fatou Pen from the Legal Drafting Department. We deeply appreciate the invitation to come over here to make this clarification. I would first like to state, Honorable Speaker, that the bill, the Prevention and Prohibition of Torture Bill 2020, certainly drew its inspiration from the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment. There is absolutely no doubt about that. And the definition adopted of torture under the bill is very similar in all respects with that of the convention, except with regards to the extent of its application. I must say that the convention, as you have rightly observed, or as was rightly observed by the expert, restricts the application of torture only to official acts. That is, acts, torture committed by officials or persons acting in an official capacity. But nevertheless, in our attempt to domesticate torture, we have decided to apply torture to official and private acts. And if you look at the bill itself, it talks about torture in all its forms and ramifications. And why we have decided to, in the first place, what has led us as a country to even introduce or try to domesticate torture? Because we never had torture as an offense. Yeah. What we have had previously in our jurisdiction, or what we currently have, relates to, as rightly pointed by the expert, assault and grievous bodily harm. Yeah. But these are offenses that do not equate to torture. Torture can be of more severity. So what we are doing in the bill is try to elevate the offense of grievous bodily harm. Let me give a graphic illustration. We are all living witnesses to the proceedings of the TRRC. We have seen or heard about the offense of torture being meted out. Now, of course, if we want to charge torture, we will not be able to do so because we do not have a domestic legislation. We can only fall back on the offense of grievous bodily harm as presently in our criminal code. But that itself does not capture the severity and degree of the offense that was meted out by perpetrators. Because what was meted out was torture, a very severe way of inflicting punishment and of a broader scope. So naturally, what we are doing here is to criminalize torture, introduce torture, criminalize it, and make it applicable to all official and private acts. We have had instances, in fact, those of you who would have followed the news recently in one of the Latin American countries, there was this group of private individuals who would kidnap people suspecting them of being witches or practicing sorcery, and then mete out all forms of punishment to them with a view to obtaining confessions from them. Now, if such things were to happen in this country, what do you charge them with? It would be grievous bodily harm. But they have done things which really amount to torture, and these are private people. So it makes a lot of sense for us to apply the offense of torture to private groups and individuals, because the offense of torture is not only an act that can be meted out or committed by people in private capacity. Now, what we are doing here also if I may say, has found support in other jurisdictions that have also tried to domesticate the International Convention. Uganda is an example. Kenya is an example. I've been informed that the bill, the act from Uganda has been circulated. And if you look at it, it clearly incorporates both official and private acts. Perhaps why the convention restricts it to official acts, it might be because for other jurisdictions applying the convention, they may have perhaps other laws relating to torture in their domestic legislation. But we never had such. And I am of the strong opinion that we are doing the right thing by domesticating and incorporating both official and private acts as for the purposes of the offense of torture. We are criminalizing torture, and it can be committed in both official and private capacities. We can have groups which are not necessarily acting on the private capacity, official capacity, or groups which are not acting on the instructions from the state and yet involved in acts of torture. How do we punish such groups? We will be creating a lacuna in the law if we do not incorporate private acts in our domestic legislation. And this is why I believe, Honorable Speaker, we have made the case, we have incorporated the concept of both official and private acts. Thank you very much.
Thank you very much.